5 seconds to go. Start. Therefore, the test as to whether sanction is necessary to prosecute a public servant will depend on whether the acts complained of are so integrally connected with his duties as a public servant. If they do, then sanction is a requisite, and there cannot be any uniform rule that an offence of criminal misappropriation or criminal breach of trust would always be outside the scope of Section 197 CRPC. The relevant observations are reproduced herein below. The result of the authorities may thus be summed up. It is not every offence committed by a public servant that requires sanction for prosecution under section 197(1) of the Code of Criminal Procedure, nor even every act done by him while he is actually engaged in the performance of his official duties, but if the act complained of is directly concerned with his official duties, so that if questioned, it could be claimed to have been done by virtue of the office, then sanction would be necessary, and that would be so irrespective of whether it was in fact a proper discharge of his duties, because that would really be a matter of defense on the merits, which would have to be investigated at the trial and could not arise at the stage of the grant of sanction, which must precede the institution of the prosecution. In our judgment, even when the charge is one of misappropriation by a public servant, whether sanction is required under section 197(1) will depend upon the facts of each case. If the acts complained of are so integrally connected with the duties attaching to the office as to be inseparable from them, then sanction under section 197(1) would be necessary. But if there was no necessary connection between them and the performance of those duties, the official status furnishing only the occasion or opportunity for the acts, then no sanction would be required. The result then is that whether sanction is necessary to prosecute a public servant on a charge of criminal misappropriation will depend on whether the acts complained of hinge on his duties as a public servant. If they do, then sanction is requisite. But if they are unconnected with such duties, then no sanction is necessary. A five-judge bench of this court in Matajog Dobe versus H.C. Bhari reported in AIR 1956 SC 44 acknowledged that slightly differing tests had been laid down under section 197 CRPC, but the difference in those tests were only in language and not in substance. The court laid down a more refined test that there must be a reasonable connection between the act done and the discharge of the official duty, and the act must bear such relation to the duty that the accused could lay a reasonable but not a pretended or fanciful claim that he did it in the course of the performance of his duty. Therefore, what one must ascertain is whether the act and the official duty are so interrelated such that it can be reasonably postulated that it was done in the performance of the official duty, though possibly in excess of the needs and requirements of the situation. The relevant observations are as follows. Slightly differing tests have been laid down in the decided cases to ascertain the scope and the meaning of the relevant words occurring in section 197 of the code. Any offence alleged to have been committed by him while acting or purporting to act in the discharge of his official duty, but the difference is only in language and not in substance. The offense alleged to have been committed must have something to do or must be related in some manner with the discharge of official duty. No question of sanction can arise under Section 197 unless the act complained of is an offence. The only point to determine is whether it was committed in the discharge of official duty. There must be a reasonable connection between the act and the official duty. It does not matter even if the act exceeds what is strictly necessary for the discharge of the duty, as this question will arise only at a later stage when the trial proceeds on the merits. What we must find out is whether the act and the official duty are so interrelated that one can postulate reasonably that it was done by the accused in the performance of the official duty, though possibly in excess of the needs and requirements of the situation. The result of the foregoing discussion is this: there must be a reasonable connection between the act and the discharge of official duty. The act must bear such relation to the duty that the accused could lay a reasonable but not a pretended or fanciful claim that he did it in the course of the performance of his duty. Furthermore, in Dhananjay Ram Sharma versus M.S. Upadhyay and others, reported in AIR 1960 SC 745, it was clarified that the mere fact that an opportunity to commit an offence is furnished by the official duty is not such a connection of the offence with the performance of such duty so as to justify even remotely the view that the acts complained of are within the scope of the application of Section 197 CRPC. This court in P. Arulswamy versus State, reported in 1967 1 SCR 201, was also concerned with an offence under Section 409 IPC, and it was opined that the act must be directly concerned and connected with the official duties of the public servant, such that it could be claimed to have been done by virtue of his office. Furthermore, it is the quality of the act that must be emphasized on. The act must not be totally unconnected with the official duty. Only if it falls either within the scope and range of the official duties or is in excess of it, then Section 197 CRPC would stand attracted. The court had stated as thus: it is not therefore every offence committed by a public servant that requires sanction for prosecution under Section 197(1) of the Criminal Procedure Code, nor even every act done by him while he is actually engaged in the performance of his official duties, but if the act complained of is directly concerned with his official duties, so that if questioned, it could be claimed to have been done by virtue of the office, then sanction would be necessary. It is the quality of the act that is important, and if it falls within the scope and range of his official duties, the protection contemplated by Section 197 of the Criminal Procedure Code will be attracted. An offence may be entirely unconnected with the official duty as such, or it may be committed within the scope of official duty. Where it is unconnected with the official duty, there can be no protection. It is only when it is either within the scope of the official duty or in excess of it that the protection is claimable. Stop.